12:05 in the afternoon here on 90.3 FM. You're listening to Helping Seniors of Brevard, heard every Wednesday from 12 noon to 1 o'clock. And it's time once again to get the show underway. And let's catch up with Nancy Deardorff, who's the host of our show for today. Hi, Nancy.
Hi, John. How are you?
Good.
Thank you so much for that wonderful introduction. You know, this is my first time hosting Helping Seniors of Brevard Radio.
I know.
So you can rescue me if I get into trouble.
All right, we've got the safety net standing by.
Thank you. Well, good morning to you, John, and welcome to the Helping Seniors of Brevard Radio Hour every Wednesday at 12 noon right here on WEJF 90.3 FM. I am your host for today, Nancy Deardorff, Operations Director and Senior Care Navigator. In for Carrie Fink today, who is on vacation. Just want to let you know, a lot of people ask us, what is Helping Seniors all about? Well, Helping Seniors is your source for senior information, education, advocacy, resources, and referral. And our mission is to improve the quality of life for our seniors here in Brevard County. We lead seniors to the resources they need, be it legal, financial, health, household, and other issues affecting seniors. Give you a little bit of background in case you haven't heard, or if you've heard before, to drive that point home. In the mid-1990s, our founder, Joe Steckler, a retired United States Navy captain, founded the Brevard Alzheimer's Foundation, which is still today one of the most important organizations and resources that we have here in Brevard County. And in fact, Joe's clubs, which exist in South County in Micco, Central County in Melbourne, and Titusville in North County, still bear his name today. And in 2001, Joe saw the need for seniors in Brevard. He saw the need went beyond those that needed care for dementia and Alzheimer's, and he created Helping Seniors of Brevard. And his goal was to create an organization that helps seniors on a broad spectrum by providing education, advocacy, and resources to seniors and those who love seniors. You see, Joe recognized that knowledge is power, and he set on a mission to help seniors by encouraging seniors to develop their own aging plan, which is our goal. Joe reminds us to take a proactive approach to aging. Don't wait for a crisis to seek out your information. This year, we're calling our aging plan Get Your Ducks in a Row, which you may have noticed in Senior Scene magazine. And essentially what we mean by that is plan ahead. Much like a hurricane plan, an aging plan is a plan that helps you prepare for issues that many seniors may face as we grow older. How do you do this? You do this by staying informed. And that is our goal here at Helping Seniors of Brevard. Our goal is to empower seniors and connect seniors to the resources they need, and we do this through our Helping Seniors media outreach. So, first of all, we have our Helping Seniors newsletter. In the center section of Senior Scene magazine, which is published monthly and distributed to over 500 locations throughout Brevard County, our newsletter is packed with educational articles written by experts in their field, as well as our senior resource directory. And our thanks to John Fredrickson, publisher of Senior Scene magazine, for his support. How else do we do this? Well, thank you to this station, WEJF 90.3 FM. John, hi there.
Hello again.
Jim, hi there.
Wait. Let me get his mic on.
Hello there.
And Eric, who's not mic'd, thank you for making our Helping Seniors Radio Hour possible every Wednesday at 12 noon. This is a 1-hour program packed with information and education by subject matter experts and professionals in their field. And we also have Helping Seniors TV, which airs 3 times a day, 5 days a week on Space Coast Government TV, which is a 30-minute program focusing on important topics for seniors. Plus, our current and past Helping Seniors newsletter, Helping Seniors Radio Hour, and Helping Seniors TV are all available to you on our website. So please visit that if you're looking to look up a subject that's important to you at helpingseniorsofbrevard.org. A reminder to everyone, our free community education series is the last Monday of the month at 10:30 a.m. at the beautiful Zahn Beachside in their Nautilus Ballroom. This is a live 1-hour presentation by experts in their field who are also available for questions and answers, and Zahn Beachside serves complimentary coffee and Danish and snacks. So we encourage you to come out and join us. Stay educated, stay connected and informed, and meet with our experts. So we have a lot of ways that we reach the public. And I want to just let you know that we have our Helping Seniors information line, which is operated Monday through Friday, 9 a.m. through 5 p.m. We receive over 400 calls a month on our senior information line. Now, I want everyone who's listening to understand that this is not an emergency line or an urgent phone call line or a crisis line. It's not a hotline, but we want you to feel free to reach out to us. Our number is 321-473-7770, and our phone lines are busy, so if you get a voicemail, be sure to leave me a message and contact information, and I will absolutely call you back. Also, what I want to say is we operate on a very frugal basis, and we depend on our sponsors and private donations. I like to consider us the small nonprofit that does big things. If you would like to be a sponsor, or if you would like to donate to Helping Seniors of Brevard, you can go to our website at helpingseniorsofbrevard.org, or you can reach out by phone at 321-473-7770 for more information. And very important, I know this is important to folks, 100% of your donation stays right here in Brevard County to help our seniors live a better quality of life. With that said, today I am very pleased to have Bill Johnson as my guest. Bill Johnson is a longtime friend and supporter of Helping Seniors of Brevard. He is a Florida Bar Board certified in the area of elder law since 2004. And he is founder of William A. Johnson, PA, Elder Law, Medicaid, and Estate Planning. Welcome, Bill.
Good afternoon, Nancy.
Good afternoon, Bill. How are you today?
I am doing well, thank you.
You know, I think you're a little humble, and one of the things that I'm going to ask you is to kind of review your bio because and your background, because a couple of things that I face on our helpline, which I answer, is people wanting to know the background of someone so that they know what they're getting into when they call, and it creates a sense of trust. So I know you're a little too humble to say this, but I want to say Bill Johnson is a 2-time winner of the Elder Law Section Member of the Year Award. He's president of the Space Coast chapter of the Florida State Guardianship Association. He served on the board of directors and chairman for the Brevard Alzheimer's Foundation and was the 2006 president of the Brevard Association of Human Services. So today, Bill, we're going to talk about will and trust litigation. Dun, dun, dun.
Dun, dun, dun.
And I myself have been a victim, recipient, whatever you want to call me, of that. It's a very tricky thing. So if it's okay with you, what I'd like you to do first, Bill, because you're first of all, I have to thank you for your support of Helping Seniors. And you take time. Bill is a very busy attorney for a very busy law firm, and he takes his time to come down here and do the radio with us. So here's what I'm thinking. There's listeners that listen to us that have heard you before, but they're not in the situation about will and trust litigation. So they kind of listen to you, but not maybe fully, right?
Okay.
Because it doesn't apply to them right now. And then there's those that go, oh, now I'm in that situation and I wish I paid attention to him more. So there are listeners that are going to want to hear more about that.
Well, today will be a primer in how to avoid will and trust litigation. So it'll be a topic that most people will find interesting.
Awesome. So I have some questions for you. As somebody, I haven't gone through the litigation part, but I've certainly been a person involved with wills and trusts. So I have some basic questions for you that I thought would be a good basis before we get into the litigation part, if that's okay with you.
Go ahead and shoot.
Okay. So first of all, Bill, what I want to know, and for you to tell our listeners, what is a will, who needs one, and why?
A will is a document wherein you devise your estate to certain individuals, and also in the will you can make reference to who is going to be what we call your personal representative. That's Florida's word for executor. And you can also put in there your burial instructions, who would be guardian of your kids if you have minor kids. So there's a wide variety of things you can put in a will. Basically in Florida, it has to be a written document. You have to sign it in the presence of two witnesses, each who sign it in your presence. So everybody has to sign in the presence of each other. And ideally, it should also have something called a self-proof attached, where a notary signs an affidavit that they saw the witnesses and you signed the document. That makes the will self-proving. Now, all wills go through probate, okay? The key to wills and trusts is that not all assets go through probate. So if you have assets that are held jointly with somebody with some rights of survivorship, those will not go through probate. If you have an asset that has a beneficiary on it, that does not go through probate. And if you have an asset that's in a trust, that does not go through probate. So not all assets go through probate, but wills would go through probate. So in a nutshell, there are three ways to avoid probate. That's have joint ownership with survivorship rights, have a beneficiary on it, or have it in a trust. Now, why do wills go through probate, and what is probate? Probate's the process where we admit your will to the court system, and then the judge looks at it, and if the will is fine, then they appoint your designated personal representative by a court order, and they give them something called letters of administration. And that acts kind of like a durable power of attorney. It gives them access to all your assets so that they can amass them. Then they have certain duties, which are to run that ad, notice to creditors in the newspaper. They have to do an inventory. And then once the creditor's claim period expires, then they decide whether to contest or pay out the claims. Then whatever's left over after the cost of administering the estate, they distribute to the heirs, and then they file the paperwork to wrap it all up.
Well, that was a very confusing, simplified and confusing answer for the average person. But, Bill, I get it. So here's what I get a lot. I have a will so that things don't need to go to probate.
Nope. All wills go through probate. That's the process where your personal representative gets appointed. Now, a trust document where you name a successor trustee to take over after you die, once they put on that hat to be your successor trustee, then they can mass all the assets that are in the trust, distribute it, pay your debts, distribute them to your heirs. And because we have that alternative system of putting somebody in charge, paying your debts, and distributing the assets to heirs, we don't have to go to the court system to do that. That's why trusts avoid probate.
Well, you just probably answered most of my second question is, so I asked you what a will was, And I told you a lot of callers think, well, I have a will, so that avoids probate for my family. So my second question is, what is a trust? Who needs one and why? And you answered that. But here's the third question. Should you always have both a will and a trust, or are the circumstances where a person only needs one of these things?
If you have a trust, you still need a will. It's called the pour-over will. The will says simply, I leave everything to my trust. And what it is there to do is if there's some asset that you forget to put in your trust or doesn't have a surviving joint owner or doesn't have a beneficiary on it, that will's there to catch it. It'll still that asset will still have to go through probate, but then it will deposit it in your trust, and then your trust will be what distributes it to your heirs.
Wow, there's so much to this. So Bill, at what point in life for most people, in other words, when should someone consider doing a will and doing a trust?
Well, a will as soon as you turn 18, and everybody should have a will. A trust, usually you have to take into consideration the upfront costs are a lot more than doing a will. So if you don't have significant assets, you may not want to do a trust initially. But however, a trust is a good mechanism if you have minor children, you have kids that spend everything you give them and you want to dole the money out over time, or you have property in multiple states. Those kinds of things are useful to have a trust.
So let me get this straight for our listeners who may have never experienced this before. What do you think, Bill, what do you advise should be included in a will, and what should be included in a trust?
Well, that leads right into the will and trust litigation. The first issue is capacity. Do you have the capacity to make a will and or a trust? And generally, the standard is, do you know what your estate consists of, who you want to leave who your kids are, and how you want to leave your estate to your children? And we get people who come in the office and want to do a will, and I ask them what their kids' names are, and they can't even remember them. So that should be a key right there that they can't do.
What do you do in that circumstance?
Well, we don't do the will. They're past the point of being able to do a will. The other thing is we have to ask them what their estate consists of and determine how they're going to leave it to those individuals, whether it's going to go to the kids, or are we disinheriting a child, or are we leaving it to other relatives? They might not have children. If they can't tell me who those people are and how they want to leave the assets to them, again, we're not going to be doing a will or a trust.
Do you ever have significant others, extended family, immediate family, that come to you on behalf of the person who's trying to do the will or trust, that's trying to lead you in a certain direction of perhaps they've known, maybe it's a son or daughter, and they know what their loved one's wishes are. So they come to you with their loved one in tow, and they say, this is what my mom wants. You can't really get mom or dad to articulate that. What do you do in that situation?
That's a great question, because a will and or a trust can be thrown out for a couple different reasons. 3 of them happen to be undue influence, coercion, or duress. Undue influence is where the person has a confidential relationship. Maybe they're a caregiver. Maybe they're the child who has mom living in their house. And then they exert some influence over the individual such that the individual's free will is no longer theirs. And usually
so Bill, how is that determined?
It's a great question, because
I imagine you get some sort of red flag in your head, right?
Yes. So the first thing you do is you meet the client without the kids present,
okay,
or whoever brought them present. And then you can ask them some simple questions. Is anybody forcing you to do this? You're doing this of your own free will, and go through all those capacity questions.
No, I have to interrupt you again. So there are, as somebody who spent 36 years practicing nursing, I know that there are people out there that implicitly trust their sons, daughters, whoever that is, and they're going to give you a yes, I trust them beyond belief. So what do you use beyond that?
So you asked me how you prove undue influence.
Yes.
You don't have to actually have proof that the undue influence occurred, because under Florida law, it's presumed to have occurred if the child called the lawyer, the child took the parent to the lawyer's office, the child was present while the will was discussed, the child knew the contents of the will prior to the signing.
Oh, that's so good to know.
The child has a copy of the will. Because remember, the first part of undue influence is a secret relationship. So you're never actually going to have proof of the actual undue influence, because that always occurred behind closed doors somewhere.
Right.
So it is presumed to occur in those circumstances, and there's a case called the Carpenter Case. And then what happens is, under Florida law, the burden shifts to the proponent to prove that there was no undue influence.
Explain proponent.
The person who wants the will admitted into probate.
Thank you. Okay, for our listeners.
So the burden shifts, and then they have to prove there was no. So it creates a presumption, which is what we call a burden shifting presumption. So for the viewers out there, remember, if your mom wants to leave you something, make sure your mom's the one who calls the lawyer's office, drives herself there, meets with the lawyer, and does all the things without you present, because you may be creating a situation of undue influence if you accompany them, make the appointment, drive them there, that kind of thing.
So what I'm hearing from you, Bill, is plan ahead before you have the need for this. Plan ahead, and the person doing the will or trust should make their needs known ahead of time on their own while they have capacity, so they don't put their loved ones at risk for being questioned, and also so that they protect their own selves for what their wishes are posthumously, right?
Exactly.
Okay. All right. Well, we have so much more to talk about. I still have some more questions for Bill before we get to the essential will and trust litigation. But this is your halfway mark on Helping Seniors Radio, and we'll be right back.
Our time coming up on 12:34 on this Wednesday afternoon. You're listening to Helping Seniors of Brevard with your host Nancy Deardorff and our special guest for today, Attorney Bill Johnson. Nancy, why don't you go ahead and take the second half here?
Thank you again, John. Really appreciate you. I am your host for today, Nancy Deardorff, Operations Director and Senior Care Navigator, in for Carrie Fink today for Helping Seniors of Brevard Radio. And I'm here with my guest, Bill Johnson of William A. Johnson, attorney. And so, the one thing I haven't said yet, Bill, is if somebody wanted to seek your legal advice, how would they reach you?
They can call us at 321-253-1667.
Thank you so much. And if anybody forgets that, you can always call us here at Helping Seniors of Brevard at 321-473-7770, and I can connect you with Bill or a whole other host of resources for seniors. So we left off talking about wills and trust. We talked about capacity. And we left off talking about undue influence. That is the influence that people have over people that may or may not have both a will or a trust. So take us into the second half, Bill, talking about undue influence and what that means.
So undue influence applies to anything that would create a transfer of property. So not only does it apply to wills and trusts, but it could apply to a deed. You know, if you bring mom into the lawyer's office and say, Mom wants to transfer a deed to us, it could apply there. It could apply to, taking mom down to the bank and getting put on as a beneficiary of her bank accounts, things like that. So it is pretty expansive. Now, I also mentioned the two other things, coercion and duress. Coercion is just old-fashioned arm twisting, where you're working on them to twist their arm to get them to do something.
Right.
Duress is a little more harsh. Duress is basically putting a gun to their head, and forcing them to do something. And I did have a case where they had an elderly lady locked up in an apartment. She was wheelchair bound. She was 100% dependent on her relatives for food. Couldn't go anywhere, couldn't do anything. And they told her they're going to take her to a lawyer's office and she's going to do a will, leaving everything to them. And they even brandished a gun, basically insinuating that, they would do away with her if that did not happen.
Right.
So, I mean, that's an extreme example, but that is a perfect example of duress.
So, Bill, I have all these questions that I made out before the show, right?
Okay.
But in talking with you, I mean, they're all going out the window. And I get calls every day.
Keep going. I'll weave them into the dialogue.
Okay. I get calls every day on our senior helpline, which is 321-473-7770. Now, before I get into it with you, I want to make clear to our callers, we are not an urgent hotline. We're not a hotline. We're not an urgent phone number. We're not an emergency phone number. We're not a crisis phone number. But you can call us anytime about any variety of issues. I will always call you back. My goal is within 24 hours. Our phone lines have been super busy lately, so it might be after that. But we're certainly not a crisis, urgent, or emergency hotline. 321-473-7770. But I have gotten calls, Bill, from significant others. So maybe you can speak to this. Significant others where, and this is pretty common call. A lot of the calls we get on our Helping Seniors information line are related to homelessness or at risk of homelessness, right? So a lot of them are related to significant others who have lived with their significant others for 10, 15, 20 years, sometimes starting in another state and then ending up here in Florida, where one of the one of the parties owns the home and the other one is living there for reasonable rent or their Social Security. And then suddenly I get a call and it's a senior saying, I've lived with my significant other. They've passed away. I was not in their will. I'm living in a house, condo, whatever. And now I'm facing homelessness because the family wants to sell the condo and kick me out. And now they have no place to live. Can you speak to that?
I can speak to that. The, primary issue here is that, Florida doesn't recognize common law marriage. So just because you've lived with somebody for a while doesn't give you any rights. If you're married, you do have certain rights in the homestead, even if your name's not on it, including the right to use it for the rest of your life. If you're not married, well, then you're living there at the whim of the owner. And of course, if the owner dies, now you're dealing typically with their kids. The only thing you could really do to solidify your position would actually have like a lease agreement or something that says can live there for a year or something of that nature, so that even if the owner dies, then you still have a leg to stand on to reside in the house at least to the end of the lease term.
It's so you and I haven't talked before the show, and it's so poignant that you should say that, because I had a call from a neighbor of a gentleman that had a significant other, living with his significant other 20 years, starting in New Hampshire, which, according to the caller, does have common law marriage. Gave up his home, entered this relationship with this woman. They ended up moving to Florida. She ended up buying property under her name, but we don't have common law. She passed away. Gentleman living in house. Now family wants house. And he literally does not have enough to survive on outside of, say, subsidized housing for the elderly, which there's a 1 to 2 to 3 year waiting list depending on where you go. There's actually only one building that has a 1 year waiting list. And my suggestion, of course, you were one of the referral sources that I gave, but in addition to that, I suggested that the family play nice in the sandbox so that the gentleman, because they were wanting to kick him out so they could sell the property, I said, if the family could play nice, let this gentleman live there for a year while he applied for one of these subsidized housing for an elderly. He would have a place to live for a year, then move in there, and then after that, they would be free and clear of him. He would have a place to live for the rest of their lives, and they could live with not knowing that they did not kick an elderly person to the curb to be homeless.
Right.
So it's kind of, I want to say strange, but it's not so strange because you just brought up a similar scenario without knowing that phone call that I got.
I would have approached, I haven't had that exact fact pattern, but one of the things I would have looked up is whether or not, because they were in Connecticut and lived there and satisfied the Connecticut common law marriage, whether or not they would be deemed to have been married.
Yeah. And that was the question of my caller. So, of course, I referred to you.
Okay.
So you may be getting that call. So, but at this point, I've asked you a lot of questions, and we're talking about will and trust litigation. So, Bill, lead us into that. What is will and trust litigation? What leads to that? And what is your advice to our listeners?
We talked a little bit about that, whether or not people have capacity to do a will. And the main questions are, do they know what their estate consists of, who they're leaving the estate to, their kids, and how they want to leave it to them. That's generally the standard for capacity to do a will. We also talked about what happens when people bring people to lawyers' offices to do a will or something of that nature. Are they exerting undue influence, coercion, or duress on that person, where that person's not acting under their free will in doing the will? One thing with undue influence, usually there's got to be some other sort of underlying, infirmity of aging or dementia or something else going on that weakens their mind, because we're subject to undue influence all the time. I mean, you sit home and watch TV and they're constantly barraging you with commercials to buy stuff. Doesn't mean you're going to go buy it.
Right.
Because you know how to differentiate between all the commercials you see and go to the store and get what you want. But when you start to get a weakened mind and your mind's not your own, then you're subject to all these other things.
Right.
The other thing that comes up is just the will or trust is not properly executed.
And I had a question about that because I have some experience with that in the last few years. And, I'd like to consider myself an intelligent person, practicing as a registered nurse for 33 years. I really thought I was kind of in the know, but when it came to legal stuff, boy, did I learn a lot. I think I mentioned to you on a program earlier that I was shocked at the sticker price for an attorney for my loved one who needed to do will and trust. And as I was into the whole thing, I realized that the amount of money that my loved one paid for an attorney to appropriately establish and administer a will and trust, and maybe I'm not using the right terms, Bill, was pretty cheap, actually, compared to what they saved, my loved ones saved, and the pitfalls that they could have experienced. It was a huge education for me, Bill, and I just feel so ignorant because I really thought I was a smart person, and with this whole thing, I was not. So can you address that, and also the people, because I get calls about this, Bill, the people who say, I don't have much, I can just do it online or write out my own will. So that's a loaded question.
Okay.
Go.
So we'll talk about execution. Like I said, you have to execute it in front of two witnesses who witness you execute it, and then it should have a self-proof where a notary signs an affidavit that they saw everybody execute. I can tell you, I would say at least 1/3 to a half of the documents I see people do online are improperly executed. I had somebody come in, they had a will they got off of one of the online providers. They had signed it, and then one of the witnesses had signed it the same day. The other witness, they put down a different date, and then the notary put down a third date.
Right.
And there's no way all these people could have seen each other sign in the same room if they were all signing on 3 different days. And then some people just think the witness slots are extra.
Right.
You don't have to do that.
Right. So they're blank.
Yeah, they just signed it themselves, and they think that'll hold up. So if you don't do the proper execution of the will, it will be thrown out. Now, you can have a handwritten will. You still have to have it properly executed. So I had a case not too long ago where the gentleman didn't want to go to a lawyer. He handwrote his will. And then they went to one of these shipping stores where they have a notary. And so he signed. Somebody from the store signed as a witness. And then just one of the customers signed as another witness.
Okay.
And then the notary at
Is
the
that
store.
valid, Bill?
Yeah, it's valid.
Okay.
However, it got contested.
Okay.
So now we got to find the witnesses. Well,
oh, boy.
Believe it or not, I hired a private investigator. He was able to find the lady who was the customer in the store, and she was willing to sign an affidavit that she saw him sign all that. Otherwise, the whole thing would have been thrown out.
Wow.
So there is some security, and I'm trying to. I think the notary only notarized the signature of the testator because he didn't put that block in properly. So otherwise, the whole thing would have been thrown out.
Well, and the reason, Bill, I ask you so many questions is because I get these calls on a daily basis, and despite our education, which we're going to continue, and I have to thank Attorney Bill Johnson for continuing to be a supporter of helping seniors of Brevard and continuing to be on the radio and write articles, because our whole goal is to educate seniors. But still, if you're not in the thick of things, or if a particular situation does not apply to you, people tend to ignore that, right, Bill? So that's why we have you on to repeat yourself, basically.
I hate to say it, but a lot of the stuff we see, by the time it gets to us, it's too late.
Yes.
The person died, they thought they were covered, or they become incapacitated, and they thought the power of attorney was good, and they come to us, and it's not.
Yeah, and that's what I want people to avoid. Now, I can't help but go here to this place with you on this radio show because we serve everyone from every socioeconomic background. So, first of all, tell us a little bit about yourself. If you could take a minute to kind of review your bio. I know you're a humble person and you do a lot for our community, but could you get past that for a moment to tell people about your bio so that they know if they want to call you what they're getting into?
Okay, I've been in Florida since 1977 and went to school, junior high and high school down in Stuart, Florida. And then I went to the University of Florida, got my BA in political science, and I went to the University of Florida College of Law and got my Juris Doctor from there. And you mentioned a whole bunch of civic activities.
Yes.
There's a few more, but probably the more important stuff is that I was actually legislative co-chair for the elder law section for 4 years. So I helped write a lot of this legislation and work on it. And then currently I've worked my way up from being the secretary, treasurer, substantive vice chair to administrative vice chair, which puts me in line to be chair-elect next year and then chair of the elder law section of the Florida Bar's elder law
That's
section.
huge, Bill. That's huge.
Right.
People should know that, because we have people that are listening that are going to need a good lawyer and they want to know something about that lawyer. And maybe you can tell me about if someone can't afford an attorney. What are your thoughts about, say, Brevard County Legal Aid and Community Legal Services of Mid-Florida? Could you speak to that for a couple
Brevard
of
County
moments?
Legal Aid, you just go to them and you fill out a financial affidavit, and if you meet their criteria, they will assign you to an attorney who's volunteered to represent people.
Tell us about what those organizations are, though, Bill.
Well, Brevard County Legal Aid,
Yeah.
that's what they do, is assign attorneys to people who can't afford attorneys.
Yeah.
And they do a ton of great work. And
This is pro bono work,
This is
and
pro bono.
this is volunteer work from local attorneys, right? And
Correct.
paralegals?
Correct.
Yeah.
And Legal Aid as an organization itself is funded through the interest off attorneys' trust accounts, our IOTA trust accounts. They get a portion of that for their administrative expenses, which regretfully probably doesn't cover their costs. They have to do some fundraising themselves.
Sure, yeah.
And they get some grants from the Brevard County Bar Association Foundation and things like that. But they do a lot of good work, a lot of pro bono work. So there are people who will do these things out there for free for people who can't afford them.
Well, I just have to tell you, Attorney Bill Johnson, William A. Johnson, I just have to thank you, not only for supporting Helping Seniors of Brevard and a lot of other organizations within the community, and being an awesome attorney, for just being an awesome person and sticking up and advocating for the seniors in Brevard County. I have to really, really thank you for that. And all the time, I mean, you're a radio guest so often, and you're one of the least available people I know, and you still make time to come here to Helping Seniors Radio. I really appreciate that. Thank you, Bill Johnson, elder care
welcome.
attorney. We just can't thank you enough. With that, folks, I want to remind you of our 6th annual car raffle fundraiser event, which will be held Saturday, October 29th from 6 p.m. to 9 p.m. at the American Muscle Car Museum. I would like to thank our longtime friend and supporter of Helping Seniors of Brevard, AJ Hires. You will have your chance to win a car from one of AJ Hires' 4 dealerships. That is a 2022 Kia Sportage, a 2022 Mazda Miata, a 2022 Dodge Challenger, or a 2022 Chevy Camaro. The winner gets to pick. The grand drawing event takes place October 29th from 6 to 9 p.m. at the American Muscle Car Museum. This is North America's largest private collection of American muscle cars and memorabilia, folks, and it's not open to the public. The owner, Mark Pylock, is kind enough to offer this beautiful venue for our grand drawing event, and Mark provides free beer, wine, soda, and snacks. It is a great take-in for either a date or for the whole family. Even if you are not a car enthusiast, this is a great take-in. And I would almost guarantee, if you're not a car enthusiast on your way in, you will be on your way out. To participate in this grand event and for your chance at winning your choice of one of 4 cars, the 2022 Kia Sportage, Mazda Miata, Dodge Challenger, or Chevy Camaro, you have to be in it to win it, as Carrie would say, right? A $25 donation gets you 1 ticket, a $100 donation gets you 5 tickets, and your ticket is not only the chance to win a car and your entrance into the grand drawing event at the American Muscle Car Museum the night of the event. Keep in mind, you don't have to be present to win, but I don't know why you would want to miss it, because the American Muscle Car, Bill, have you been there?
I have been there.
What do you think about it?
For the drawing. It's an amazing place.
It's pretty amazing, isn't it?
It is.
And I don't know if are you a car enthusiast or no? Tell the truth.
I like that place, yeah.
Oh, you like that place. So even if you're not a car enthusiast, would you agree it's just an amazing take-in?
It is.
So for all of you listening, tickets are available at all Boniface Hires dealerships, or you can go to our website at helpingseniorscarraffle.com, or you can reach out by phone at 321-473-7770. Many of our supporters get tickets and actually gift them to other people. We have people, I want to tell you about a gentleman that contacted me about his father and his mother. They are celebrating their 60-year anniversary. They are from out of state. We actually get callers from out of state and ticket buyers from out of state. And so he purchased tickets for he and his wife, his mother and his father, for their 60th anniversary, because his father is such a car enthusiast that they will be there October 29th. And he doesn't even care about winning. He just wants to be there amongst the car. So, folks, there are no losers, because your ticket is not only your chance to win a car, not only your entrance into the grand drawing on October 29th to the American Muscle Car Museum, but your charitable donation is tax deductible. All of your donations stay here in Brevard County. So it's a very worthy and charitable cause. And by donating, you're already a winner. You are a champion in helping seniors of Brevard to improve the quality of life of seniors in Brevard County. So I will be there October 29th, and I hope to meet you all there. And good luck to all the people that purchased or donated for tickets. I hope you win the 2022 Helping Seniors Car Raffle.